So as a sample, this is what it would sound like when they're speaking. Yep, okay.
Test 1, 2, 3. Testing 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. You got it? Sounds good. Test, test. Okay, bye.
before working for the committee, I worked for Don Young, so we were looking at the implementation on this, so, yep, I'm glad we.
Good morning, everyone. The Subcommittee on Indian and Insular Affairs will come to order. Without objection, the chair is authorized to declare recess of the subcommittee at any time. The subcommittee is meeting today to hear testimony on 4 bills that are before us. Under Committee Rule 4F, any oral opening statements at hearings are limited to the chairman and the ranking minority member. I therefore ask unanimous consent that all other members' opening statements be made part of the hearing record if they are submitted in accordance with Committee Rule 3.0. Without objection, so ordered. I ask unanimous consent that the gentleman from Alaska, Mr. Begich, the gentleman from Florida, Mr. Soto, the gentleman from Florida, Mr. Gimenez, and the gentleman from Arizona, Mr. Stanton, be allowed to sit and participate in today's hearing. Without objection, so ordered. I will now recognize myself for an opening statement. Welcome, everyone, to the first hearing for the Subcommittee on Indian and Insular Affairs for the 119th Congress. I'm honored to serve as the new chairman of the subcommittee, and I look forward to working with our American Indian, Alaska Native, and Insular partners. The subcommittee is meeting today to discuss 4 bills. First on our agenda is H.R. 410, the Alaska Native Vietnam-era Veterans Land Allotment Extension Act of 2025, sponsored by Congressman Begich. This legislation would extend the Alaska Native Vietnam-era Veterans Land Allotment Program for an additional 5 years. This program was authorized in 2019 with the intent to fulfill the promise of the Alaska Native Allotment Act to certain Alaska Native veterans. Currently, the program is set to expire on December 29th, 2025. Data from the Bureau of Land Management shows that approximately 378 applications are currently in process and that the agency still needs addresses for approximately 150 eligible veterans. Extending this program another 5 years is a common sense solution to ensure effective program administration. Second, we have H.R. 412, sponsored by Congressman Bergman, which would authorize the Bay Mills Indian community to sell, transfer, lease, encumber, or otherwise convey lands that the tribe owns in fee simple without needing congressional approval. This would exempt land the tribe owns in fee simple from the limitations imposed by the Non-Intercourse Act. While the Non-Intercourse Act was initially enacted to protect tribes from further loss of land, in recent years, the law has generally not interfered with the ability of a tribe to buy, sell, or lease land that it owns in fee simple. However, in some instances, title insurance companies have interpreted the act to apply to fee simple real estate that is owned by the tribes and have refused to provide title insurance, which has encumbered economic development and job creation in those tribal communities. The Bay Mills Indian community seeks their own individual exemption to provide clarity on their land ownership. Several other tribes in the United States, including in Michigan, have sought and received similar exemptions. Third, we have H.R. 504, sponsored by Congressman Gimenez, the Miccosukee Reserved Area Amendments Act, which adds the Osceola Camp to the tribe's reserved area. The bill also requires the Secretary of the Interior to take actions to protect the structures within the camp from flooding. In 1998, Congress passed the Miccosukee Reserved Area Act, or MRAA, to authorize the tribe's permanent residency in the Everglades while maintaining the right of the federal government to engage in restoration and protection of the area. However, the MRAA did not include the Osceola Camp, which is still subject to a special use permit. By incorporating the camp into the tribe's reserved area, the tribe will have the authority over the village area and be able to work to prevent flooding and preserve village infrastructure. Our final bill is H.R. 741, Stronger Engagement for Indian Health Needs Act of 2025, sponsored by Congressman Stanton. The bill would elevate the Indian Health Service Director position to an Assistant Secretary within the Department of Health and Human Services. Advocates of this legislation argue that elevating the Director of the Indian Health Service to an Assistant Secretary level would bring greater attention and focus on health in Indian country. The bill, however, does not provide any tangible direction as to how this would address that need beyond elevating the position. I thank our witnesses for being here with us today, and I look forward to having a robust discussion on these bills. At this time, the chair will recognize the ranking minority member for any statement.
Thank you so much, Subcommittee Chair. I've heard great things about you from your colleagues, Democrats. say good things about you. And I know that on this committee, we often work on an incredibly bipartisan basis. And so I am very pleased to be with you here at your inaugural subcommittee meeting. And as I noted, this subcommittee has a long history of bipartisanship, regardless of the administration or who happens to be holding the gavel. And this was the case. Last committee, it was the last Congress, it was the case when I was chair, and the wonderful Don Young from Alaska was my ranking member. I remember his words at one of our very first meetings. He goes, "Madam Chair," I'll try to, "Madam Chair, let's just do a bill and fix it all." And I actually was young enough as a congresswoman to think we could do that, right? Which we can't, but we can address historic injustices, and that's exactly what this committee is authorized to do. And because of our trust responsibility, that's what this committee must do. And we have done that over the years to address things like making sure we restore land, we address the health crisis, we address law enforcement needs in Indian country, we protect sacred sites. The trust responsibility and the government-to-government relationship is at the heart of the work we do. And for that, I'm very thankful, and I think the subcommittee members really love the fact that this committee does this. But I will say that at this point in time, I do want to raise a slight alarm, and that is last week, tribes across the country found that their access to funds that they were entitled to pay for nurses, to pay for law enforcement, to pay for 638 contracts were frozen. They could not access those funds, and it created chaos and confusion. It created worry. We know that order, Trump's order freezing all funds, was withdrawn. But I am still hearing from tribes that there are certain programs that they can't access. And I know this must be inadvertent. It must be a consequence of thinking that tribes might be part of DEI or something, but they are not. They are tribal sovereigns who are entitled to these funds that we are providing to them as part of our trust responsibility. So, Mr. Chairman, I look forward to working with you and look forward to working with Chair Westerman, because I know you understand these issues very well, so that we can make sure that these kinds of constrictions on the funds that tribes are entitled to can be removed. So I look forward to that. And now let's get to the great bills we have before us today. First, I want to thank you all for coming. We know that you come from great distances and that you pay your own way here, right? And it is an economic hardship sometimes to make it here. We know it is a dedication to your communities that bring you here to testify in front of us. The first bill on the agenda is H.R. 410 from Representative Begich. And we always say to our veterans, thank you for their service. It is more important to also provide veterans with the service and the respect that they deserve. And this bill does that by extending the timeline for eligible veterans to apply for the land allotments that they might not have been able to apply for because they were in active military service. Representative Bergman's bill 412 would authorize the Bay Mills Indian community of the state of Michigan to convey land and interests owned by the tribe. Sometimes it needs to go the other way, and you need to have the authority to be able to do that. H.R. 504 from Representative Gimenez helps protect the Miccosukee tribe's sovereignty over a historic tribal village within Everglades National Park, while also allowing important restoration, recognizing that tribes are sometimes doing the most important restoration and conservation work. They've been doing it since millennia. We need to make sure we allow them continue to do that. And Representative Stanton, thank you for being here today for your bill to address the elevation of the Indian Health Service position within the Department of Health and Human Services. We know that tribal health is underfunded, and perhaps raising this and raising the issue to a higher level will help it get the attention it deserves. Thank you very much for holding this hearing on these very important subjects, and I look forward to hearing directly from the witnesses, and I yield back.
Thank you, Ms. Ledger-Fernandez. I too look forward to working with you in this next Congress. At this point, the chair would recognize the ranking member of the House Natural Resources Committee, Mr. Huffman, for an opening statement. Mr. Huffman.
Thank you, Mr. Chairman, and congratulations to you, and welcome to Congress and to the committee. I also want to thank our ranking member, Teresa Ledger-Fernandez, for her continued leadership on this subcommittee and commitment to Indian country, and I want to strongly associate myself with her remarks about the context for which we are in which we are meeting. There has been a barrage of executive orders, I would argue demagoguing and grandstanding against DEI in ways that need to be thought more carefully about, because when you do that, especially when you attack equity, you are attacking tribal sovereignty, you are attacking all the progress that we have made for Indian country in recent years. I don't think that's what many of my colleagues across the aisle actually want to do or intend, but it's absolutely happening. And I have been talking to tribal leaders throughout my district and around the country. They are deeply concerned about this. There is the potential to freeze critical funding for programs that they depend on. Lives will be lost. Entire communities will be devastated if we're not much more careful. We gotta reel this back in, folks, and we could use some help across the aisle in that regard. So I do want to extend my thanks to all the tribal leaders who have traveled. As the ranking member said, we appreciate you, your willingness to set aside time and to be here for this important conversation. And, you know, we may not always agree on the specific approaches to addressing the challenges faced by Indian country, but this subcommittee has a history of bipartisan work and a shared commitment to advancing legislation that benefits tribal communities. And with that in mind, I'm really grateful that the first subcommittee hearing is bringing us back to the work of moving legislation that will actually benefit tribal communities. The bills we're considering cover a range of issues that fall into this subcommittee's jurisdiction. Mr. Begich's H.R. 410 extends the Alaska Native Vietnam-era Veterans Land Allotment Program to ensure that Alaska Native veterans who served in Vietnam have the opportunity to participate in the allotment process. This is a right that they were previously unable to access due to their service, and so I'm grateful for that. Mr. Bergman's H.R. 412 provides the Bay Mills Indian community with the authority to manage their non-trust lands, giving them relief from federal law, similar to what we have done for other similarly situated tribes. And so that is an important step forward for that Native community. And then H.R. 504 expands the Miccosukee reserved area to include the Osceola camp, strengthening the tribe's ability to self-govern and address flood risks facing that village. Very importantly, we have Mr. Stanton's Stronger Engagement for Indian Health Needs Act, which would elevate the Director of Indian Health Services, IHS, to the position of Assistant Secretary for Indian Health. This will ensure a greater focus on the healthcare needs of tribal communities. That is the point. That is critically important, and it will help ensure that the needs of tribal communities are at the forefront of national health policy decisions. By elevating the IHS director to this position, we are creating a direct and empowered voice for Native health at the highest level of the Department of Health and Human Services. In closing, I want to thank again our witnesses for joining us. I look forward to hearing your invaluable testimony, and to the members and to folks watching at home, as difficult and fractious as our politics are right now, this subcommittee really can be a place where we get things done for Indian country. I hope that is the case, but we got to be mindful of this broader context that we're working in, which is absolutely worrisome, and we've got to find ways to come together and reel back some of the threats to Indian country that are also part of our national discourse right now. And with that, I yield back.
Thank you, Ranking Member Huffman, for that opening statement. I will now recognize Mr. Stanton from Arizona for 5 minutes to speak on his legislation. Mr. Stanton.
Thank you very much, Chairman Hurd and Ranking Member Ledger-Fernandez, for allowing me to wave on for this significant hearing. And before I start on my particular bill, let me just say thank you to Ranking Member Ledger-Fernandez for making that important point on the OMB memo that froze the funds. It treated our tribal partners, tribal nations, as if they were an NGO or a political subdivision, and they're not. They are sovereign nations, and in any budget decision should be treated as such. I want to say thank you to our witnesses for traveling to D.C. and testifying on this important issue before the committee today, providing for Alaska Native veterans, protecting native lands, and what my bill, the Stronger Engagement for Indian Health Needs Act, intends to do, elevating the healthcare needs of Indian country. Specifically, my bipartisan bill, who I partnered with Representative Joyce of Ohio, would elevate the Director of Indian Health Services to Assistant Secretary of Indian Health Service within the Department of HHS. Under current law, the Director of IHS does not have certain authorities like pay and hiring authorities, which are important for improving employee recruitment and retention. Those are reserved for assistant secretaries. As an assistant secretary, the head of IHS would have these expanded authorities, improving continuity and quality of care provided by its employees. This is crucial for our Native populations in Arizona and across the whole country. Indian health is chronically underfunded. In 2023, the average expenditure for Native American patients under the IHS was about 1/3 of healthcare expenditures for non-Native individuals. That's unacceptable. That isn't because Native people are less sick. This means they are simply receiving less care. Report after report from the National Institutes of Health and the U.S. Commission on Civil Rights cite that understaffing and underfunding of Indian health system leaves many basic needs of our Native American community unmet, leading to lower life expectancy and disproportionate rates of disease. The recent Supreme Court ruling in Becerra versus San Carlos Apache only adds to the uncertainty of IHS' fiscal future, making action now to add leadership to the IHS so important. And this is a bipartisan issue. The late, great Senator John McCain from Arizona introduced this legislation originally in 1994 during his time in the Senate. This bill passed 5 times as a standalone bill and once more in the Indian Healthcare Improvement Act of 2007. And there is precedent for doing an action like this. In 2016, Congress elevated the director of the Substance Abuse and Mental Health Administration to an assistant secretary to respond to the opioid crisis. I'm glad to see Mr. Locklear here, interim CEO of the National Indian Health Board, to testify on this important bill. The NIHB has done so much to empower Native American communities to heal, to grow, and to thrive, including their work in the addiction space, combating the opioid and fentanyl epidemics that have a huge impact in Arizona and in our Native communities. I know that elevating the Director of Indian Health Service to an Assistant Secretary of Indian Health Service will have a tremendously positive impact on their organization, their ability to coordinate, and will better help serve the tribes and communities. In closing, I want to recognize the leadership of the outgoing Director of Indian Health Services, Rosalind So. She worked tirelessly to improve healthy outcomes on Native lands, and I thank her for her service. I look forward to working closely with her successor. My hope is that with the passage of the Stronger Engagement for Indian Health Needs Act, future leaders at the Indian Health Services will, as assistant secretaries, have a direct line of communication to the secretary on all matters related to Indian health policy, resulting in better health care delivery and stronger health outcomes for Indian country. Thank you. I yield back.
Thank you, Mr. Stanton, for that statement. I would now like to recognize Mr. Begich from Alaska for 5 minutes to speak on his legislation.
Thank you for the opportunity to speak on H.R. 410, the Alaska Native Vietnam-era Veterans Lands Allotment Extension Act of 2025. This bill extends the application period for the Alaska Native Vietnam-era Veterans Land Allotment Program by 5 years, ensuring eligible veterans can claim the land they were promised. For decades, thousands of Alaska Native veterans who served in Vietnam were unfairly denied the ability to apply for land allotments due to their service overseas. While Congress took steps to correct this issue, the previous administration slow-rolled processing eligibility applications and conveyances, leaving many veterans in limbo. As of January 2025, out of more than 2,000 eligible veterans, only 41 applications have been certified, and only 18 veterans have received their conveyances. Fortunately, executive orders issued by the current administration have reinstated federal land withdrawals previously revoked, unlocking lands that had been closed off under the prior administration. This expansion of available land increases opportunities for veterans to select and receive their rightful allotments. This bill will give them time to participate in the program with ample land for viable selections. These veterans served our country honorably, and we need to make sure that they are not denied what they were promised. Thank you for your consideration of H.R. 410. I urge the committee's support, and I yield back.
Thank you, Mr. Begich. Witnesses? Okay. I thought we had Mr. Gimenez here for just a moment, but he seems to have stepped out. So with that, it's now my pleasure to introduce our witnesses for our panel. First is Mr. Nelson Unapuk from the Alaska Federation of Natives in Anchorage, Alaska. Mr. Unapuk, welcome. Thank you for your service. I know that you mentioned that you sometimes have a little bit of a hearing issue. Please let us know if you cannot hear any of the questions from us. Next is the Honorable Whitney Gravel, who is president of the Bay Mills Indian Community in Brimley, Michigan. Welcome. Next to her is Mr. Anthony C. Locklear II, interim chief executive officer of the National Indian Health Board in Washington, D.C. Welcome, Mr. Locklear. And last is the Honorable Talbert Cypress, who is chairman of the Miccosukee Tribe of Indians of Florida from Miami, Florida. Welcome, Mr. Cypress. Let me remind the witnesses that under committee rules, they must limit their oral statements to 5 minutes, but their entire written statement will appear in the hearing record. To begin your testimony, please press the talk button on the microphone. We do use timing lights. When you begin, the light will turn green. When you have 1 minute left, the light will turn yellow, and then at the end of the 5 minutes, the light will turn red, and I will ask you to please complete your statement. I will also allow all witnesses on the panel to testify before member questioning. Now, at this time, I would like to recognize Mr. Gimenez from Florida for 5 minutes to speak on his legislation. Mr. Gimenez.
Thank you, Mr. Chairman. Thank you to Chairman Hurd and Ranking Member Leger and Fernandez for holding this hearing today and considering my legislation, H.R. 504. Miccosukee Reserved Area Amendments Act. For those of you who do not know me, I'm Representative Carlos Gimenez, and I proudly represent Florida's 28th Congressional District, which runs from Miami-Dade County to the beautiful Florida Keys. My district encompasses the Florida Everglades and the Miccosukee Reserve Area. I have seen firsthand the vital role that the Miccosukee tribe has played in our great state's history, culture, and environmental stewardship. The Miccosukee Reserved Area Amendments Act ensures that the Miccosukee tribe has the legal authority to manage and protect their land and preserve their traditional way of life. Specifically, the bill would amend the Miccosukee Reserve Area Act to include the Osceola Camp as part of the Miccosukee Reserved Area. The Osceola Camp is an inhabited tribal village within the Everglades. It is a site of incredible historical and cultural importance to the tribe, and the bill aims to allow the tribe to optimize water flows to the Everglades National Park without affecting residences of the camp. This would allow the tribe to raise the structures in the camp and safeguard the areas from destructive flooding, which threatens the area. The Miccosukee tribe has been responsible stewards of the Everglades and have worked tirelessly to protect the unique and fragile ecosystem that is the integral lifeblood of conservation in Florida. It is only right that we amend the MRA area to allow the tribe to protect the Osceola Camp. Miccosukee tribe's leadership and conservation efforts have helped maintain the cultural heritage, natural beauty, and the biodiversity of South Florida. The tribe should be granted the autonomy to protect their land, and I urge support of this bill. Lastly, I would like to thank Miccosukee Tribe Chairman Talbert Cypress for being here today. I believe he's here. There he is. His presence highlights the importance of this legislation to the tribe and South Florida as a whole. Thank you very much, and I yield back.
Thank you very much, Mr. Gimenez. At this time, I think we're ready for the witness testimony. The chair now recognizes Mr. Nelson Unapuk for 5 minutes. Mr. Unapuk.
Good morning. Mr. Chairman, members of the committee, Representative Begich, thank you for giving me an opportunity to testify on H.R. 410. Before I get to my statement, let's hold a moment of silence in remembrance of our troops who have fallen in the battlefields and since they came back. Mr. Chairman, my name is Nelson Nangapak Sr., Vice President Emeritus, Alaska Federation of Natives. I retired from AFN in 2013. However, I remain active on veterans issues and have been since I got involved. AFN is the largest Alaska Native organization in the state. For the record, AFN is in favor of H.R. 410, the proposed amendments regarding the date that our veterans can apply for allotments. Our Alaska Native veterans population is declining at a very rapid pace. So I think resolution of this issue must be done sooner rather than later. As you consider H.R. 410, let's keep the following in mind. The American Indians, including the Alaska Natives, have the highest percentage of our membership serving in active duty in U.S. Armed Forces. During the Vietnam War, our troops, our members stepped forward, 42,000 of them, 95% of them on voluntary basis. Close to home, Congressman Begich probably knows this. During World War II, the Alaska Territorial Guard was formed in 1942. The patriotism of the Alaska Natives were demonstrated because more than 6,000 of us volunteered. What stands out about ATG is this. Our Alaska Native members of ATG served some up to 5 years, 24/7, and were never compensated by the Department of Defense. They were even refused DD-214s. We lobbied Congress and were successful in passing legislation that mandated the Department of Defense to issue DD-214s for our ATG members who served during that time. Mr. Chairman, there is a very important element of the present Native Allotment Law. It's a good law. However, the land issue is the issue that we're faced with. Let me use two members, Robert Beans and heirs of were not able to apply for native allotments because the land available for them were at least 150 to 750 miles. So I think, Mr. Chairman, land must be resolved in such a way that our interests are protected. Thank you very much for giving me an opportunity to testify on this bill. I ask that my written comments and my stated comments be incorporated into the record.
Thank you so much, Mr. Anapuk. They certainly will, and I thank you for your testimony. The chair now recognizes the Honorable Whitney Gravel for 5 minutes.
Ani Bojo, good morning, Honorable Chairman, as well as Ranking Member Fernandez and members of the committee. My name is Whitney Gravel, and I currently serve as the president of Bay Mills Indian Community. It is truly an honor to be here today and testify in support of HR 412, legislation that is critically important to the future of our tribe. First, I would like to extend my deepest gratitude to Congressman Bergman for his leadership in introducing this bill and for standing with us to ensure its passage. And I also want to thank this committee for taking this time to consider this issue. It's a unique issue that doesn't only impact Bay Mills Indian community, but many tribal nations across the country. For a little bit of background, Bay Mills Indian community has called the shores of Lake Superior home since time immemorial. Our ancestors ceded vast lands to the United States in treaties signed in 1820, 1836, and 1855, lands today that make up nearly 40% of the state of Michigan. In return, we were promised the ability to govern ourselves and determine our future, yet today outdated and conflicting legal interpretations hinder that very promise. HR 412 addresses a fundamental issue, the ability of Bay Mills to freely manage and sell our own non-trust fee simple lands without unnecessary federal oversight. The confusion surrounding the status of these lands has created barriers that prevent us from fully utilizing the land for economic development, housing utilization, public health care, as well as created barriers that prevent us from making sure that they are used in the most productive way possible. We purchase land, but then are rendered unable to ever sell it again. We pay taxes on land, but then can do nothing with it. Title insurance companies refuse to recognize our clear authority, making it nearly impossible to transfer property. Companies will not purchase land without title insurance, which then leads to land becoming abandoned and not utilized to the best of its ability, either for infrastructure development, economic development, land preservation, and sometimes public services that are being provided. This bureaucratic red tape is not only inefficient, it is extremely unjust. The Department of Interior has already acknowledged the problem, supporting similar legislation for other tribes. In fact, Congress has acted on behalf of many other tribal nations, our sister tribes in Michigan, including the Saginaw Chippewa Indian tribe, the Sault Ste. Marie tribe of Chippewa Indians, as well as tribes in Florida, Minnesota, Louisiana, Oklahoma, and Oregon. And now it is the time to do the same thing for Bay Mills Indian community. The solution is simple. HR 412 affirms our right to self-determination by removing any ambiguity around our non-trust lands. It ensures that Bay Mills Indian community has the same rights as other tribes have been granted, the right to make decisions about our land without having to seek congressional approval every time we wish to act. This process has been something we've worked on for an extremely long time. We have tried many different pathways to resolve this issue over the course of several decades. Yet land that was purchased some 50 years ago, 75 years ago, is still within our land holdings because we cannot sell it, we cannot develop it, we cannot make sure it is used in the most productive way possible. At the core of this legislation, it is truly about fairness, economic opportunity, and ultimately tribal sovereignty. By passing HR 412, Congress will empower Bay Mills Indian community to invest in our future, to create jobs, and to continue to build a strong and self-sufficient community. I urge this committee to support HR 412 and move it forward for passage. The time to act is now, and I sincerely appreciate your commitment to Indian country. Chi Miigwech, and I welcome any questions that you may have. I will yield the rest of my time. Thank you.
Thank you, Ms. Gravel, for that testimony. The chair now recognizes Mr. Anthony C. Locklear for 5 minutes. Mr. Locklear.
Good morning, Chairman Hurd, Ranking Member Ledger Fernandez, and the distinguished members of the subcommittee on behalf of the National Indian Health Board and the 574 sovereign, federally recognized American Indian, Alaska Native tribal nations we serve. Thank you for this opportunity to provide testimony on HR 741, the Stronger Engagement for Indian Health Needs Act of 2025. My name is A.C. Locklear. I am a member of the Lumbee Tribe of North Carolina and serve as the Interim Chief Executive Officer for the National Indian Health Board. The Indian Health Service, also known as IHS, is an operating division of the U.S. Department of Health and Human Services that delivers culturally competent health services for American Indians and Alaska Natives. IHS is one of 4 core federal health delivery systems. The IHS Director oversees an agency of approximately 15,000 employees that provides direct care services to patients. They oversee the parts of the implementation of the Indian Self-Determination and Education Assistance Act and collaborates with other divisions and agencies of the department. Additionally, the IHS is the principal federal entity charged with fulfilling the federal trust responsibility for Indian health. This legislation seeks to better meet the trust and treaty obligations of the federal government by elevating this critical role to an assistant secretary. Elevating the director of IHS to an assistant secretary of HHS is a long-time request among tribal leaders, tribal members, and American Indian Alaska Native health advocates. Elevating the IHS director to assistant secretary for Indian health would raise the priority and presence of Indian health matters within HHS and the federal government. The nominee for secretary of HHS, Robert F. Kennedy, stated, "I'm going to bring in a native at the assistant secretary level," during his confirmation hearing in front of the Senate Health Committee. He later commented that all of the agency's decisions will be conscious of their impact on First Nations. This is the first time that a secretary nominee for HHS has committed to making these changes within the agency. Elevating the IHS director to the assistant secretary would provide appropriate recognition of the director's role and would resource the office to address operational needs of Indian health, such as hiring and pay. It would also clearly identify the new assistant secretary as a primary advisor to the secretary on all Indian health matters that exist broadly across the department's divisions and agencies. It is time for Congress to commit to the health of tribal people by passing legislation such as HR 741. Congress has the constitutional authority and responsibility to provide for Indian health. Indeed, Congress must act to realize the elevation of the IHS director. Because the director and the duties of the director are established in statute, nominated by the president, and confirmed by the Senate, Congress is the only body with the authority to elevate the director to assistant secretary. Elevation of the director will also bring necessary attention and focus on Indian health disparities. American Indians and Alaska Native people experience the worst health outcomes compared with the rest of the United States population. Year after year, the federal government has failed American Indians, Alaska Natives by drastically underfunding Indian Health Service far below the demonstrated need. Due to chronic underfunding, the Centers for Disease Control and Prevention reported that life expectancy for American Indians, Alaska Natives has declined nearly 7 years. That means that life expectancy for our people is now 65 years, the same as the life expectancy of the total U.S. population in 1944. In 2018, the U.S. Commission on Civil Rights found that federal funding for Native American programs across the government remains grossly inadequate to meet the most basic needs that the federal government is obligated to provide. Generally, Native American program budgets barely perceptible and are a decreasing percentage of the agency's budget. This legislation would raise the profile of Indian health, which is important to bring education and attention to the health disparities tribal communities face. An assistant secretary for Indian health can better support the U.S. government in meeting its treaty and trust responsibilities for health care. It also brings Indian health in parity with other sister departments which already enjoy the recognition of assistant secretary. To appropriately implement this legislation's purpose, Congress should also fully fund IHS to meet the healthcare needs of tribal members adequately. In conclusion, the Stronger Engagement for Indian Health Needs Act of 2025 is one small step towards meeting the trust and treaty obligation between the federal government and tribes. The federal government made its promise in its treaties to provide for, among other things, the health care of tribal members. This legislation will help repair this one portion of broken promises of the federal government and will support a step towards healthier tribal communities. Thank you.
Thank you very much, Mr. Locklear, for that testimony. The chair now recognizes the Honorable Talbot Cypress for 5 minutes. Mr. Cypress.
Let's try it again. Good morning, Chair Hurd, Ranking Member Ledger Fernandez, and members of the subcommittee. Thank you for the opportunity to appear before you today. I am Talbot Cypress, Chairman of the Miccosukee Tribe of Indians of Florida, a federally recognized tribe located in the Greater Everglades in South Florida. The views expressed herein are those of the Miccosukee Tribe. I appreciate the opportunity to discuss H.R. 504, the Miccosukee Reserved Area Amendments Act, which would expand the current boundaries of the Miccosukee Reserved Area, or MRA, to include the Osceola Camp. Thank you also to Rep. Gimenez for sponsoring this legislation. We strongly support H.R. 504, which would ensure appropriate governance for the Osceola Camp, and call on the Park Service to work with the tribe to elevate structures in the camp to protect it from floodwaters from the Central Everglades Planning Project. The Miccosukee Tribe was federally recognized in 1962, and after that recognition, our villages within the Everglades National Park were managed as a special use permit granted by the National Park Service. In 1998, Congress passed the Miccosukee Reserved Area Act. This act provided a legal framework under which the members of the tribe could live permanently and govern their own affairs in the villages set aside for the tribe's use within the park. The Miccosukee Reserved Area Act of 1998 has been a resounding success for the tribe and for the Everglades National Park. Our residential community, the national park, its waters, and its visitor access have all been well protected. However, there remains one special use permit within the Everglades National Park. And this is my father's family's village called the Osceola Camp, named after the descendants of the war leader Osceola, who was executed after the Second Seminole War. My ancestors lived in the Osceola Camp for generations, and H.R. 504 would add Osceola Camp to the Miccosukee Reserved Area, thus completing the protection of tribal communities remaining within the Everglades National Park. The incorporation of these 30 acres into the MRA will create a more consistent legal framework for tribal residents and law enforcement personnel. Once the Osceola Camp becomes part of the MRA, residents can be included as residents of tribal lands and can more easily access tribal emergency and infrastructure services. In addition to expanding the Miccosukee Reserved Area, H.R. 504 requires the National Park Service to carry out necessary work to elevate the camp. The Central Everglades Planning Project, when completed, will restore the natural flow to a 3-mile stretch of the Everglades. However, the Osceola Camp is right in the flowway of that water, which will be released under the plan. Work has already begun by the National Park Service and Florida Department of Transportation to elevate the camp and its traditional structures above the new floodplain height. The work will be done together with the Tamiami Trail Next Steps project, which is elevating the roadway to protect it from rising water levels. As the village is on the border of the Tamiami Trail roadway, this approach is efficient. However, without this work to elevate structures, the village will be under imminent and substantial risk of frequent flooding. We strongly support H.R. 504 as consistent with the federal trust responsibility and ensuring continued self-governance. I truly appreciate the opportunity to address this subcommittee and thank you for your support you have shown to tribes and our sovereignty. I look forward to any questions you may have. Shinabish, thank you.
Thank you, Mr. Cypress. Shonabisha, for that testimony. We're now going to move to the question portion of this hearing. The chair now recognizes himself for 5 minutes of questions. Ms. Gravel, a couple questions for you. First, the Non-Intercourse Act waiver legislation will only affect the land that the tribe owns outright, correct? It doesn't affect any of the land held in trust?
Yes, that is correct, Chairman.
And in your written statement, you mentioned how confusion from title companies impacts your tribe's ability to dispose of non-trust lands. If you aren't able to have a title company work with you on a transaction, what happens to that transaction?
Yes, in many instances where we have engaged with economic development corporations or other business partners, we have found that without being able to obtain title insurance, the transaction falls through. Many folks are seeking title insurance in order to protect their business transaction. The realty companies seek it in order to protect, them certifying the sale of land or sometimes the lease of land. And so without any support from the title insurance companies themselves, we see routine failure of any type of transaction that we try to engage in.
Ms. Gravel, that's a consistent answer that you get from all the title companies. It's across the board.
Yes, from everyone, and they talk to each other as well. So as you know, we've been encountering this issue in the state of Michigan. They're very aware of it, and they understand that without this legislation going through, that we won't be able to do anything to resolve it.
Great, thank you, Ms. Gravel. My next question is for Mr. Cypress. Can you tell us, do you know why the Osceola camp wasn't originally included in the Miccosukee Reserved Area Act?
No, right now, I wouldn't have that answer for you, but I know when lands are placed into trust, or as in this case, the reserved area, they usually like the land to be contiguous. And the Osceola camp is 6 miles away from the residential area and tribal government area.
Okay, thank you. In your testimony, you mentioned how the Miccosukee Reserved Area Act has been successful. Can you expand a little bit on that, particularly on the ability of tribal members to access emergency services?
Yes, the Reserved Area Act treats the tribal community as a reservation. So the tribal government is able to provide services for those areas, and it removes the restrictions from the counties or the cities that don't have jurisdiction in our area.
Okay. Mr. Unapuk, in your written statement, you mentioned examples of where lands available for selection by Alaska Native Vietnam veterans were a far distance away from their home, and they didn't have knowledge of those lands. Can you help us understand a little bit more about how that impacts these eligible veterans as well as their heirs?
Mr. Chairman, Alaska Native people values the land as part of their survival. There are family ties and linguistic ties to the land that we use to live off the land. And that's why it's important that the lands that are made available for them be brought closer to home.
And can you, for those eligible veterans that ultimately choose to select lands that are far away from their home, despite that distance, do you think those individuals get the same value and meaning from that land than from land they could select that's closer to their home?
Mr. Chairman, I don't think so, because there are no cultural ties to that land, nor can we understand what those lands mean to people that are living in that area.
Thank you very much. One last quick question for Mr. Locklear. Can you help me understand how the need for Indian health funding connects to a position title with the Assistant Secretary within HHS?
Yes, Mr. Chairman. I think, as Representative Stanton mentioned earlier, being able to elevate the Assistant Secretary will provide a direct line of access to the Secretary, be able to elevate those priorities, but also across the department to other issue areas. It will be the principal advisor to the Secretary on all Indian health matters. As I'm sure you're aware, there are so many different Indian health needs that are impacted by agencies' decisions, whether it's CDC, whether it's HRSA, to be able to have that parity with the rest of the agencies along with that direct line to the Secretary would help kind of elevate many of those needs. And absent of increasing the resources to Indian Health Service itself, it would help them be able to coordinate resources with other agencies to be able to better utilize those resources in more efficient ways.
Thank you, Mr. Locklear. I see my time has expired. At this time, I'd like to recognize Ranking Member Ledger Fernandez for 5 minutes.
Thank you, Mr. Chairman. And I'm going to start my questioning with some observations with regards to the Non-Intercourse Act. I mean, it really had a particular intent because, as we know, tribal lands were decimated prior to its enactment. But right now, it does not suit the purposes of self-determination. And I think that President Gravel, your testimony highlighted that, of what it feels like for one tribe to have to go and get an act of Congress to be able to sell a piece of non-trust land that you own outright. We did this in the 117th Congress on behalf of the Seminole Nation when I was chair, and on the floor at the time, I said, we need to get this fixed so that it can apply to all tribes, that we don't have to come on an individual basis to tribe, because I want you to share again with us, you had it, some in your written testimony, you mentioned it here, how much time did you lose? How much economic development did you lose? How much frustration did you gain by having to go through this process?
Yes, for me alone, I've been working on this issue for over a decade, but for Bay Mills Indian community, it's been about 30 years that they've been trying to resolve these land issues, and they've built, as you know, we become more self-sufficient and have purchased more land. Initially, it would start with one parcel, you know, the inability to be able to sell it. We would acquire additional land. We actually entered into several agreements with economic development corporations that were intended to invest hundreds of millions of dollars on the land to create housing, to create jobs, manufacturing plants. But due to the inability to sell them the land for that development and our limited ability to then only lease the land for a period of 25 years, it really hindered the development of those specific parcels that we were trying to negotiate. So there's been many different paths we've tried to take. We've tried to lease it, we've tried to sell it, you know, we've tried to develop it ourselves and have not been able to. And so now we're here, you know, seeking this legislation so that we can finally be able to sell land. It is truly that simple, you know, to purchase land and then want to sell it.
So thank you very much, and I, you know, hope this bill makes it through both this committee onto the floor. It should be non-controversial and become law, but I will be working on legislation so that we can make this process available to everybody with, you know, the right safeguards. But it is essential for self-determination. I really want to give my true appreciation to the recognition by Mr. Anapak for the patriotism of Native Americans. When you point out that Native Americans participate at the higher rate of any other group, I think it's important to recognize that's like almost 20% of Native Americans participate in our military service. That's almost 1 in 5 Native Americans who are patriotic warriors, and I'm thankful that we have this bill to be able to recognize that work and allow you to get those allotments. I wanted to turn to the issue of the Indian Health Service, and I think that there was somebody mentioned Hamilton. We all saw Hamilton, right? There's the line about you want to be in the room where it happens, right? And is that in essence what we're doing? It's in some ways a simple task of saying when you put IHS in that room. I was an assistant to a cabinet secretary once, and that small room where you are at makes a difference because you're not having to go through another layer. Is that kind of, it is in some senses a very simple proposal that doesn't take up a lot of space because all the rest gets worked out within the agency. Is that correct, Mr. Locklear?
In essence, that is correct. I think one example, just piggybacking off of our veterans, our Native veterans, one of the biggest tasks that the Indian Health Service Director has had in recent years is their relationship with the VA and the VHA specifically. Being able to coordinate with the Secretary and the Undersecretary for Veterans Health Administrations in a meaningful way to complete the IHS VA MOU to ensure that the agencies are coordinating efforts and resources to support our Native veterans has been an insurmountable task that has taken years and years and years. Luckily, we have had directors and secretaries who have made it their mission to come together, but with every new administration, with every new change, it becomes increasingly difficult to continue that relationship to make sure our veterans still have that support, whether they go to their VH, whether they go to Veterans Health, or whether they go to Indian Health Services. So those are some of the examples of how that really plays out in real life, is that coordination between the agencies and also within the department itself. I know we talk a lot about some issues recently have been congenital syphilis outbreak in Indian country, and being able to advise the secretary or to ask for a public health declaration. So those are some of the examples of recent issues, but you're correct.
Yeah, thank you very much. And the fact that it is bipartisan, that was originally brought way too many years ago by Senator McCain. It's a simple elevation of priority, and so I look forward to additional conversation as to whether there are any concerns and how we can make sure we get this across the finish line. With that, I yield back.
Thank you, Ranking Member Ledger-Fernandez. The chair now recognizes Mrs. Radewagen for 5 minutes.
Talofa lava. Mr. Chairman, I want to thank you and the ranking member for holding this important hearing today. And my question is for Mr. Locklear. Are you aware of specific privileges an Assistant Secretary position has that the current Director of IHS does not have? And if so, how would those privileges benefit IHS at large?
Yes, ma'am. Thank you for that question. I think one of the primary examples that was recently brought up is hiring and pay. I think that is currently reserved with the Assistant Secretary level. So with the director, there's workforce is a huge problem in Indian country generally, especially with our health systems. Being able to attract doctors, nurses is a consistent issue across the board, whether it's a tribal health facility or Indian health service facility. So being able to mitigate some of those issues through hiring practices, through pay practices, as is reserved for Assistant Secretary level person, is one example. And then I just think, in addition to that, just being able to be that principal advisor across the board. Directors are typically directed to execute a specific program, such as direct services. The Assistant Secretary would be able to have more strategy behind a lot of their work and advising the Secretary.
Thank you, Mr. Chairman. I yield back the balance of my time.
Thank you, Mrs. Radewagen. The chair now recognizes Mr. Hernandez for 5 minutes.
Thank you, Chairman Hurd. I'm inspired by the bipartisan support for these bills that respect and strengthen the autonomy, self-government, and federal participation of tribal nations, in spite of the broad authority that the Constitution bestows upon Congress. I hope to see a similar respect towards the Commonwealth of Puerto Rico and U.S. territories in the future. My question is for Mr. Locklear. Mr. Locklear, how does H.R. 741 align with the federal government's trust and treaty responsibilities? And what would this shift signify in terms of tribal sovereignty in healthcare decision-making?
Thank you for that question. As it's clearly recognized through the Constitution, through this Congress over and over and over, there is an explicit federal trust responsibility for health, and that's to provide for the health and well-being of American Indians, Alaska Natives. Indian Health Service has been that principal entity to effectuate that. While it's the entire federal government's job, they are the one that's providing direct services to our tribal nations, or they're the ones that are executing the Indian Self-Determination Education Assistance compacts or contracts. Being able to elevate the director really signifies that the federal government is putting priority towards the issues that are still continuing to face Indian country. So whether that is issues around behavioral health, suicide, and just the general health disparities that we are in a race to the bottom to currently in our positions across the board. It really prioritizes those consistent issues and shows that it is just as important as the other areas across HHS and the federal government.
Great, thank you. No further questions. I yield the remainder of my time.
Thank you, Mr. Hernandez. The chair now recognizes Mr. LaMalfa for 5 minutes. Mr. LaMalfa.
Thank you, Mr. Chairman. Thank you, panelists, for being with us here today and for convening the hearing. For Honorable Gravel from Bay Mills, a couple questions real quick on, as you attempt to do projects, do you have specific projects that lack of clarity in the current law and its interpretation that is that having a negative effect on your ability to do projects the tribe's interested in doing?
Yes, that is correct. We've tried to enter into an agreement with a development corporation near one of the lands in Lower Michigan. This development agreement was intended to build housing. And initially, when they reached out, they wanted to simply purchase the land that we held down there so that they could engage in housing development for local areas and other units of government. We had proceeded towards the final steps of negotiation with them, but as we reached out again for title insurance, that was denied. And without the assurances of title assurance being applied to the land, the agreement ended up falling through.
Can you walk me through why it was denied? Was there some aspect of, again, the lack of clarity is was there some piece of the law that was being misinterpreted or taken wrong? How's that look?
Yes, the title insurance company issued an opinion that specifically cited the Non-Intercourse Act that said, tribes did not have the ability to sell land without an act of Congress.
Right.
This general confusion is a really gray area of law that exists throughout much of the United States and has not been actually determined by the U.S. Supreme Court either. And so even though we were able to cite to other transactions where fee simple sales had occurred, they were also able to cite other examples where it had not occurred. And so without the assurances being provided or having a specific bill for Bay Mills Indian community, they denied title insurance.
Yeah, okay. Certainly, we've run into this plenty of other times, and it seems very frustrating, I think, on both sides of this microphone that every time a given tribe wants to do a transaction, it has to be a congressional action. We need to be able to trust them at this point in time that they can handle that, So we do need to clarify that more. I hope as we legislate on that, we're successful. So, Honorable Chair Cypress, now, I'm from Northern California, where we have a great amount of tribal activity and history there. And currently areas that are flooding in NorCal, but I see this as an effect on you as well. In interaction with the National Park Service on flooding effects, in this case, Osceola Camp and some of your other villages. So has National Park Service been helpful on addressing the flood capabilities or probabilities in that area?
Yes, the National Park Service has been a dedicated and willing partner in mitigation planning and execution. They have dedicated liaisons to us to work with other agencies, and also we also have regular monthly meetings with the agencies as well and the Park Service.
Would you say then overall that that working relationship is positive? Are they able to do things timely and help you get the things done that are beneficial to the tribe and the lands? In this case, flooding, or maybe other aspects too. Are you having the level of cooperation you need, or is there some other legal roadblocks towards that?
No, there's good cooperation, but the threat of the flooding has become more urgent as the project progresses. The roadway is expected to be finished in 2027, I believe.
How long have you been waiting for that roadway?
That's, well, I would say like over 10 years, like 15 years.
Has it been funding? Has it been permitting? What's been the challenge?
We've been given different excuses every time.
From the other side?
Yes,
Is this Park Service or other regulatory agencies?
other regulatory agencies.
Such as Fish and Game or?
Department of Transportation, Florida Department of Transportation.
Okay. All right. Very frustrating. We want to help streamline that. So let our committee know of further efforts, because I'm very frustrated by these super long timelines just to do simple things. You know, I work a lot on forestry, and simple projects take forever. And so it shouldn't have to be that way. I yield back, Mr. Chairman. Thank you.
Thank you, Mr. Lamalfa. The chair now recognizes Ms. Randall for 5 minutes. Ms. Randall.
Thank you so much, Mr. Chairman, and congratulations as well from a fellow freshman. I'm excited to serve on this committee with you. I have the great honor of representing the Olympic Peninsula in the far northwest corner of the lower 48, and I serve my constituents alongside the tribal councils and leaders of the Quinault, the Quileute, the Hoh, the Makah, the Chehalis, the Jamestown S'Klallam tribe, the Port Gamble S'Klallam tribe, the lower Elwha Klallam, the Suquamish tribe, the Squaxin, the Puyallup, and the Skokomish. And learning alongside and serving alongside leaders from those sovereign nations is a very powerful honor. And one of the things that has most impressed me in my time as a resident of Washington and as a fellow elected leader has been the Tribal Health Center's initiative in serving not only their tribal members to the best of their ability, but also meeting the needs in community health deserts that exist in so many of our rural communities across the country. And from combating the opioid epidemic to mental health crises to filling primary care deserts, I am so grateful. But I hear from concerned directors of health services and elected leaders that they're still facing many challenges. And you pointed out, Mr. Locklear, to Chairman Hurd's question that having Assistant Secretary would allow the priorities of Indian Health Services to be elevated in the cabinet level. But can you speak some to the unmet budgetary needs and what additional funding, if Assistant Secretary was able to advocate for that, might allow Indian Health Services to accomplish?
Yes, thank you for that question. The unmet need is astronomical based on most estimates. It's currently, I think, around $50-some billion, and it's currently funded at a significant amount less. One of the benefits of having an elevated director to assistant secretary would also be in the absence of that increase. As you mentioned, there are so many cross-cutting issues. Obviously, tribes have often taken these responsibilities on to provide health through self-determination contracts or compacts. So beyond just direct services, the Indian Health Service Director is also tasked with those other issue areas, whether it's health disparities or those things, and to work across the department to address them. So I think that one of the barriers often is, and we see this across many different departments, is being able to understand what various agencies and entities are doing and being able to utilize those resources in more efficient ways. I think that is one of the biggest benefits there, and also being able to understand where those resources are going so that the budgets are then more accurate to the needs of Indian country, so that those budgets can speak to more than just the healthcare delivery in the IHL systems and those contracts and compacts, but also they can speak to the needs beyond just those Indian Health Service and throughout the entire department.
Thank you so much, Mr. Chairman. I yield the balance of my time.
Thank you, Ms. Randall. The chair now recognizes Mr. Begich for 5 minutes. Mr. Begich.
Thank you, Mr. Chairman. Well, I'd just like to thank Mr. Engelbuck for, for your service to our nation and for your longstanding commitment to supporting Alaska Native Vietnam-era veterans in this issue. It's very important. In my own family, we have at least 2 Vietnam veterans, one of which is an uncle of mine who was a POW who served in Vietnam. He was a POW for over 5 years, and we certainly appreciate your service and understand how important that has been to our nation. One thing that I'd like to highlight for the committee and for those present is in Alaska, we have 23 distinct native languages, 229 federally recognized tribes. So when we talk about land being distant in its location and availability for selection, it really is important that Alaska Native veterans have the opportunity to select lands that are near their community and are culturally congruent to their community. So my question, Mr. Engelpuck, is, in your view, having been attached to this issue for such a long period of time, what has been the primary reason that the conveyances have been delayed? And I'll remind those present, 2,000 eligible Alaska Native Vietnam veterans, but only 18 conveyances have been completed. So why do you think these conveyances have been so delayed?
Mr. Chairman, Representative Begich, I heard only part of your question because I lost my hearing, good part of it. So I think your question, correct me if I'm wrong, your question deals with land selections. Are we talking about the villages or the veterans?
We're talking about the veterans, and I'm wondering, in your opinion, why has this taken so long to get these conveyances completed? Because we have 2,000 veterans who should be eligible and only 18 conveyances complete. So any thoughts or insight that you can provide to the committee?
Thank you very much for the clarification. One of the primary reasons why the veterans are hesitant to apply for native allotments, for example, Jacob Kakak lives up in Barrow. The nearest land that were set aside from which he can apply for native allotment is about 750 miles. Take the veterans from Southeast. They're similarly affected because of the distance of the land that were set aside from which they can apply for allotments. The late Colonel Robert Beans, a friend of mine, Vietnam War era veteran, initially was not going to apply for a native allotment because the land that was set aside for him to select was 150 miles, from lower Yukon to where that is, you have to cross Bering Sea. The people from Barrow have to fly down to Bethel, and people from southeast would have to fly to Bethel, and then another flight down to where the lands are located from which they can apply for allotments. That's why there has been such a slow application by our veterans, the distance from the land.
Thank you for that additional information. And I do think that context is very important for the committee to understand just how vast Alaska is. Alaska is 2.5 times the size of Texas. It's a very large place with a very diverse set of cultures. And it is important that those lands that people are selecting have some geographic relationship with where they live and where they've grown up. And just again, to underscore the idea that, look, the recent decisions by the new administration have reopened up lands that are now available for selection that are closer to, in proximity to these Vietnam veterans, and we need to ensure that we are taking care of this before we lose the remaining Vietnam veterans who served our country so honorably. And with that, I yield back.
Thank you, Mr. Begich. The chair now recognizes Mr. Soto for 5 minutes. Mr. Soto.
Thank you so much, Chairman. You know, in Florida, we've had native tribes in our state for over 12,000 years. I have the honor of living in and representing Osceola County, and Kissimmee started as a trading post with both our Seminole and Miccosukee tribes. The landmark Miccosukee Reserve Area Act was critical for tribal rights, as we saw many folks flee to the tree islands like Big Cypress and other areas, and of course the Miccosukee being from North Florida and beyond, finding refuge there. Chairman Cypress, thank you for being here. It's an honor to have you in front of our committee, and it'd be great to learn a little bit more about the history of Osceola Camp. What was the original reason it was never included to begin with in the MRAA?
The original MRA mainly addressed the core residential areas for the Miccosukee tribe, which is 6 miles away from where the camp is situated. The camp was established there, or the residents there moved there, my ancestors, when the national park was established, and they needed to move closer to the Tamiami Trail in order to survive. And that's where a lot of our community gatherings are held now, many events throughout the year. And it is core to our community to keep that, to keep it safe from floodwaters.
And as we see the comprehensive Everglades restoration plan progress forward, have we seen flooding or threats of flooding to the Osceola camp?
Yes, just at our last Christmas gathering, there was significant flooding that was starting to occur at the camp. We are in favor of restoration. We understand that water needs to flow that way, and we're trying to be cooperative and supportive of the plan, while at the same time protecting our tribal members and our community.
Is Florida giving you enough input as the comprehensive Everglades restoration plan is proceeding?
Yes, we've been in close contact with different agencies in Florida as well as the federal government.
And have we seen an increase in flooding because of more extreme hurricanes over the past couple of years?
It's more about management of the water, I believe, that the flooding has increased.
Well, thank you for being here. I'm excited to be able to support the bill by my fellow Floridian Representative Gimenez and plan to co-sponsor it. Appreciate you testifying, and we need to get this done. Thanks for being here.
Thank you.
And I yield back.
Thank you, Mr. Soto. The chair now recognizes Mr. Gimenez for 5 minutes. Mr. Gimenez.
Thank you, Mr. Chairman. I'm not going to take much time. I just want to say that the Miccosukees have been great stewards of the environment, especially the Everglades and the portion of the Everglades that I represent. It's beautiful. If anybody hasn't gone down there, I would invite you to go down there and take a trip through the Everglades, and they probably will guide you through there. Okay, and so the Osceola camp has been inhabited for many, many years. It's central to the Miccosukee way of life, and it's only right that we allow them to put this in the MRA. And I know that they'll again, they've just been great stewards of the environment and the Everglades, to protect the Everglades. They provide great services too. You know, I used to be the mayor of Miami-Dade County, and their services in police and fire and fire rescue are second to none. And so this is a good move, and this is something that we should do. And so, do you have anything else you want to add, Chairman Cypress?
No, just to thank you also for your support for the tribe. We greatly appreciate it, and from the committee as well. Thank you.
No, thank you very much. I yield back the balance of my time.
Thank you, Mr. Gimenez. The chair now recognizes Dr. Kennedy for 5 minutes. Dr. Kennedy.
Thank you, Mr. Chair, and thank you to the witnesses. I appreciate you being here and being willing to testify in front of us. And to the chairman, I thank you for your leadership on Indian and Insular Affairs, and thank everybody for being here and willing to take on these important issues. I hope to use my time as a member of this committee to listen to and learn about the tribes across the United States. Of course, in Utah, we have a number of tribal issues as well. And I look forward to cultivating strong relationships with all the tribes and trying to resolve the issues that you confront. And I'm with you on that. I wanted to start actually with Mr. Locklear. Thank you very much for being here. I'm interested in, as a family doctor myself, I'm interested in healthcare generally, and I really do. Many of my native patients that are recipients of healthcare in tribal circumstances, there are sometimes less than ideal circumstances that they confront. And what can we do as a committee or as Congress looks at the health care of our tribal individuals, is what can we do to promote the health and well-being of these individuals? And in this case, in your purview, what are your recommendations for what we could do to help in those areas?
Thank you so much for that question. I think the first natural answer is advancing the IHS director to assistant secretary, the elevation of those issues across HHS and the federal government, and being able to work interdepartmentally to address many of these priorities are paramount. I think most notably is in funding of the Indian Health Service. It's roughly funded at about 60% of its actual need. I think for FY25, it was approximately funded around $50 billion. The need was around $50 billion. It's currently funded around $7 to $8 billion. Wow. Most of that is made up from third-party revenue. However, it really causes a strain, which then leads to workforce issues. It leads to other things like the inability to provide specialty services, inability to provide a lot of the necessary needs for communities. So we often have issues such as our maternal health deserts, which is one of the issues that are really facing Indian country right now. And then the inability to react on a public health level, because that's not a function of Indian Health Services currently. So really looking at those issues, and I think having a more holistic look at how the various agencies across HHS are responding to those. So one of the other primary, I think, things that would help, which is very proven, is the expansion of self-governance across HHS. Looking at allowing tribes to contract or compact for the programs that are being provided outside of just Indian Health Services. So whether that's through the Substance Abuse and Mental Health Services Administration, being able to provide for their own behavioral health initiatives to address things like the opioid and fentanyl, or to be able to address suicide in their communities in the way that best suits their communities, and really being able to use that funding in a manner that's the best the tribe needs to address that. I think those would be the primary areas that I would say.
Thanks. To be clear, so you're saying that when the funding is allocated, that it's constrained in how it's used, and that if we were to loosen up that regulatory framework, that the tribes could actually use the money in a more flexible fashion to address the healthcare challenges that they confront. Is that what you're saying?
Correct. Indian Health Services and the direct services is currently able to be contracted or compacted. And we can see tribes across the country who have some of the most sophisticated health systems in their rural areas. Alaska is a great example of that. But those programs are isolated to just the Indian Health Services and those services that they provide. So the services outside of that across HHS do not have that flexibility. So being able to do that same process for those other agencies we saw during COVID, that was exactly what tribes needed to be able to respond to COVID in a quick fashion. So to be able to have those, whether it's public health infrastructure, whether it's infectious disease, what have you.
Thank you for that. I wasn't aware of that. I'd love to continue conversations. If myself and my team could potentially help move that forward, whether it's regulation or statutory, I think that kind of flexibility could be an important way for us using our leverage here to enhance the health care of these sometimes vulnerable individuals. Diabetes has been devastating for this population. Our country as a whole has suffered terribly with diabetes, but I know my friends and neighbors in the tribal circumstances are particularly affected by that. So if there's some way that I could open the door to continue conversations, I'd love to do it. I do, for Mr. Anapuk, thank you very much, for Chairman Anapuk, for being here. I was curious about the possibility that the 5 years wouldn't be enough for people to take advantage of the opportunities here. Could you, the 5-year extension, will that be sufficient to give these Vietnam veterans time to respond to this possible benefit that they and their heirs can receive, or should the time be longer than that?
Mr. Chairman, sir, let me respond to you as I thought you asked. Insofar as resolving the time issue, that's critical, because our non-veterans are dying at an extremely high rate. Insofar as land is concerned, our recommendation is Congress considers the lands that were set aside for the villages to make their land selections through Section 11 of that law, because every village in Alaska had Section 11 land withdrawals, and good part of that land was not selected. So I think if those lands are made available and be made available by mandate from Congress, it would allow our veterans to apply for allotments for lands that they are familiar with and have used.
Thank you very much
Thank
for
you.
that answer. And I see, Mr. Chair, my time has expired. I yield back. Thank you very much.
Thank you very much, Dr. Kennedy. I want to thank our witnesses for coming here this morning and for your valuable testimony. I know you traveled from far to get here. We sincerely appreciate it. I also want to thank my fellow members of the subcommittee for their questions. Members of the committee may have some additional questions for you witnesses, and we would ask that you respond to those in writing. Under Committee Rule 3, members of the committee must submit questions to the committee clerk by 5 p.m. on Monday, February 10th, 2025. The hearing record will be open for 10 business days for these responses. If there is no further business, without objection, the committee stands adjourned.
I'm dead.